right, so did a Michigan judge go too far in his attempt to scare students straight? Here's what happened. Judge Kenneth King, he ordered a teenager to be handcuffed and put in a jail uniform during a field trip to the Detroit courthouse. Now, her crime? She fell asleep while in the courtroom. I want to bring in former Broward County Judge Elizabeth Scherer to weigh in on this. So, Judge, good morning. Thanks for being here with us.
Good morning.
So this judge is facing federal civil rights lawsuit, and basically what happened after this, the court was not in session at the time that this happened, but he conducted kind of a mock trial with this student. So talk to me your thoughts about this. I mean, was this way too far?
I mean, I've seen judges do this with the consent of the parents. Let's say a child is misbehaving and the child sends the parents send the child in front of a juvenile judge, and they do this kind of scared straight program with the consent of the parent. In this case, it seems like it was just a field trip.
Right.
This is essentially a criminal charge. This is a contempt charge brought by the judge as opposed to the state or the prosecution. In order to bring a criminal charge, you need to afford the person a lawyer and a trial or a right to be heard, which I don't believe she was given either one before she was taken into custody. So under the laws, I think that he was way outside of his lane.
Well, let me just put up on the screen for folks watching this what he is actually in this lawsuit charged of doing. He is charged with unlawful arrest and incarceration, intent, infliction of emotional distress, and invasion of privacy. So when it comes to this, I mean, there's one thing when you're trying to just, verbally talk to someone, but he put her in handcuffs. She wore a jail uniform, and then basically was having, the peers, her students, colleagues there, basically conduct this trial and see if she either one would go home to her mom or one go to juvie jail. Now, it was all mock, but at the same time, it's creating emotional distress.
If the child in other words, if this was a planned group exercise where they were going to do a mock trial for the purpose of learning for these students, it would have been one thing. But
she didn't know.
But for the fact that she didn't know, to single her out, to put handcuffs on this child, there's no law that warrants a judge doing that type of a thing. Whether or not he meant well, I don't know, but certainly there's nothing that would support him doing that. On the other hand, I disagree with the civil lawyer who's representing the family in this case. I think the judge has immunity, and I don't think that the lawsuit will stand. I think it will get dismissed.
Well, let me ask you about that, because what the lawyer is saying is he would have immunity if this was a real court case. But because this was a child that was watching and observing in his courtroom, he doesn't have the judge robe to hide behind, because he was the one doing this outside of his robe, if you will.
I think the fact that there was obviously some type of an agreement for these students to come into the courtroom and to, obviously there was some kind of a presentation that was going to go on. I believe he was conducting court on another case. That's what I read, that it was a homicide case and that the girl was getting upset about it, which is why she was closing her eyes to sort of ignore it. And that's when she fell asleep. So he was conducting court, although I think he went outside of his lane, way outside of his lane in this case. I don't believe that those charges will stand.
Well, he's been temporarily suspended. He is undergoing some sensitivity training, and a little bit more background that we're learning about the case is a little girl she's basically trying to figure out where her next home is, because she's been going between homes, and that kind of led to her being tired while being there, according to her family members. So when we look at this, if he's not going to, in your opinion, be faced with any kind of charges or anything like that, if he does get back on the bench, is he going to be able to serve in his full capacity, or will people not want to be in his courtroom?
I can tell you that over the course of the last 10, 15, 20 years, the ethics committees that govern judges in different states have gotten much more strict. 20 years ago, something like this would have happened and nothing would have happened to the judge. Today, I would not be surprised if he's ultimately removed from the bench for doing this.
Really?
So although I don't think the civil case will stand, I think that he's in way bigger trouble than just a sensitivity course, in my opinion.
All right, we'll watch this one play out. As always, very good to speak to you. Thanks for coming in today.
Thank you for having me.
We appreciate it.